Imagine you're sitting down for dinner. There's a knock at the door. It isn't the mailman or neighbor, it's a squad of soldiers. They aren't here to ask any questions. They're here to move in. They're taking the guest room, eating your food, and they are not leaving. I'm Bill from the Hill, and today we're looking at the Third Amendment. Most people call this the Forgotten Amendment because it's almost never used in court. But in the world of government oversight, there are no accidents. We're going to be looking at the evidence, the history, and the modern loopholes that prove that this amendment is still the silent bodyguard of your front door. To the people who founded this country, that wasn't a hypothetical nightmare. It was recent memory. If you want to know why the Third exists, look at the Declaration of Independence. It is right there in the list of grievances against King George III. The British Parliament passed the Quartering Acts of 1765 and 1774. They didn't just want the colonists to pay for the army, they wanted the army inside the communities to keep an eye on them. It was a logistical move that doubled as a psychological one. By the time 1791 rolled around, the founders made sure that consent was the mechanical requirement for any soldier entering a private home during peacetime. No consent, no entry. It's that simple. Before we get into the modern court cases that actually tested this law, I want to hear from you. Do you think the Third Amendment is still relevant in the age of digital surveillance? Drop a comment below. Hit the like button if you value this breakdown, and subscribe to join more as we audit the rest of the amendments. Now here is where the plain English gets complicated. The text says soldier, but who is a soldier in 2026? In 1982, in a case called Engblom versus Carey, a court ruled that the National Guard counts as soldiers. That was a win for the Third Amendment because it protected the rights of strikers living in facility housing. But fast forward to 2015. In Mitchell versus City of Henderson, a family sued after police allegedly took over their house for a tactical advantage in a neighborhood standoff. The courts answered, police officers, even if they look like and act like military units, are not soldiers. This is a significant issue. If the government can bypass the Third Amendment just by changing the uniform, does the amendment still work the way the founders intended? Even with these gray areas, the Third Amendment remains a vital mechanical safeguard. It forces a legal process. During wartime, the government cannot just move in. They have to follow a manner prescribed by law. This means Congress must act. There must be a public record, and under the Fifth Amendment, they would likely have to pay you for the use of your property. It prevents the executive branch from using the military as a law unto itself. For this audit, we aren't just giving you opinions, we are providing the authoritative evidence. You are looking at the original text that guarantees the sanctity of your home. We have cited the Quartering Acts of 1765 and 1774, which you saw in the list of grievances against the Crown. This is not ancient history. It is the administrative blueprint the founders were trying to correct. When you do your own audit, in the description you will find direct references to the Supreme Court cases. These are modern, living authorities that prove the Third Amendment is not forgotten. It is currently being tested by the government. Use these links, read the case summaries, and verify the facts for yourself. The Third Amendment is the evidence that the founders intended the home to be a civilian sanctuary. It is the first line of defense for your privacy. I'm Bill from the Hill. We've cited references in the description so you can do your own audit on the facts. Thanks for watching, and we'll see you in the next one.